In terms of contacting the attorney's office?
Yes.
You can do that if you'd like, but it looks like you guys have already worked this out.
Yeah, we have. Like I have
Okay.
I apologize. Go ahead.
No, it's okay. You guys have already worked this out. I just can't, because you don't have an attorney. I can't enter this judgment today.
Okay. So do I need to get an attorney myself is my question.
Okay. Oh, right. You can if you want, but you don't have to.
Okay, well, cool. If I don't have to and that everything will be fixed on the 10th, then I'm okay with that.
88.54. Total amount to retain 37.88.54. No money judgment was requested.
All right. Ms. Schwarberg, how are you intending on getting that paid?
So we actually, it's all DJ. He's not here, I guess, but he hasn't been paying his half of rent. I haven't been then living there and I can't get in contact with him. I have been paying my half of rent, and we just sent in $2,200 that he owed from his staff just now. So it should be paid off a lot of that. We talked to the landlord and directly paid $2,200 just a few days ago. And then
Do you have that, counsel? The 22?
It doesn't look like that hit the ledger I have yet. The last payment I'm showing was $700 on March 4th. So that'll obviously the balance will include.
All right. So there's 2,200 out there. And
yeah,
what I will do then, my next date is the 10th, is next week. All right. So I'll adjourn this out 1 week. You can contact plaintiff's counsel's office, see if you can arrange how you're going to get this paid. Is he still residing in the premises?
yeah. So I've been paying my half and I've been paying a lot of his half, but I don't know why I can't get off of this lease no matter who I call. He's not even here today, which does not seem okay that I'm the only one that has to deal with this as we're both on the lease. And I've been paying all of his rent payments. So I just don't understand how this is still my problem. I don't understand how he's not being also held accountable.
Well,
I understand it's my problem.
Okay. I'll wait for you to finish and I'll explain the question.
It's on a
the answer to
delay.
the question is you signed a contract on the lease. That's why you're still involved in this. So you're still liable for the payments that are due under that lease. The dispute as between who's paying what half and whatever, that's going to be for you two to work out. But what I will do is I'm going to adjourn this out 1 week to April 10th, 2026 at 2 p.m. That's an in-person hearing. I suggest that maybe you contact plaintiff's office if the issue is that you're not residing there, but I'm not sure what you could necessarily do in that regard. But I'll adjourn it out to that date. Okay?
Okay.
So
how are we going to find where to go for in-person court? Are we going to get mailed another thing?
You'll get mailed another notice, but if you look on the paperwork that you received, the paperwork that you received has the court address on it.
Okay. And what time on April 10th then?
2 p.m.
All right. April 10th at 2 p.m. I'm unable to get mail because he lives there and won't let me in, and I don't have a mail key. So.
All right. Do you have some place to write something down, ma'am?
Yes, I can do it right here.
All right. The address is 4133 Washtenaw Avenue, and it has an Ann Arbor address. It's the same location as the Washtenaw County Sheriff's Department.
Okay. And then you said April 10th at 2 p.m.
Yes, ma'am.
Okay. Thank you very much.
Thank you. Linden Park versus Brittany Edwards.
Good morning, Aaron. Norman Whitty on behalf of the plaintiff.
Brittany Edwards?
Yes, good morning.
Okay, there you are. Thank you. All right. What is plaintiff's claim in this case?
This is a non-payment of rent case. Rent through the end of April is currently due in the amount of $3,050. Court costs in this matter are $159.27. Total amount retained $3209.27. No money judgment was requested.
All right. And Ms. Edwards, how are you intending on getting this paid?
I paid the $16.50 on Wednesday, which was the 1st. So the remaining balance would just be April's rent, and I can pay that on the 15th of this month.
The 15th?
Yes.
Okay, so I can only adjourn it out 1 week, so I'll adjourn it out to April 10th, 2026 at 2 p.m. That's an in-person hearing. What I might suggest you do is contact the plaintiff's counsel's office or your landlord, see if you can work out a conditional order of dismissal that'll give you to that date. Okay?
And we would agree to that.
Okay. All right, ma'am?
Thank you.
All right, thank you. Do we have
I
any?
get a conditional dismissal from her. Do I need to do that in person? Put it on the record, or will the court accept it just by mail?
I'm sorry?
If she does agree to a conditional dismissal before the hearing, do you need us to appear in person for that hearing, or can we do it?
No, if you have a conditional dismissal, get it to the court and then submit the Zoom forms. We're gonna let you appear via Zoom if you don't have anything else. Okay?
Sounds good. Thank you.
All right. We have a Spanish interpreter, so. All right. Thank you, Miss Edwards.
Good morning, Ms. Liliana. You're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washtenaw County, State of Michigan. Our number to proceed this morning is 1423.
Yes, thank you. Good morning.
Good morning. Can you please raise your right hand to be sworn? Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in the manner now before the court, so help you God?
Yes, I do.
Thank you.
All right. And good morning, Liliana. How are you?
Good morning, Jonah. Good. How are you?
I'm good, I think. All right. Court does call the case of Linden Park Apartments versus Dennis Fernandez.
Hola, seré su intérprete de español. El día de hoy se estaría viendo el caso de Linden Park Apartments contra Dennis Hernández.
Norman Whitty appearing on behalf of the plaintiff.
También se encuentra Norman Whitty en representación del el demandado.
Mr. Fernandez, can you state your name, please?
Dennis Omar Fernandez Rivera.
All right. How much does plaintiff claim is owing?
Bueno, ¿qué cantidad sería la que el demandado debe?
We show rent owing through the end of April in the amount of $3,750. Court costs $159.27. Total amount retained $3909.27.
Nos aparece la cantidad de renta que se debe hacia finales de abril de 3,750 más costos del tribunal, que serían 159,27, que lleva a un total de 3,909,27.
Okay, so the
Okay.
same. I'm sorry, I'm at work. I apologize for the loudness. But so the same. I heard you say something else to someone else regarding getting one and contacting one. Is that the same procedures and precautions that I need to take as well?
In terms of contacting the attorney's office,
Yes.
you can do that if you'd like, but it looks like you guys have already worked this out.
Yeah, we have. Like I have
Okay.
I apologize. Go ahead.
No, it's okay. You guys have already worked this out. I just can't, because you don't have an attorney. I can't enter this judgment today.
Okay. So do I need to get an attorney myself is my question.
Okay. Oh, right. You can if you want, but you don't have to.
Okay, well, cool. If I don't have to and that everything will be fixed on the 10th, then I'm okay with that.
You're okay with that?
Yeah, I'm all right.
Okay. All right. What, you don't like attorneys?
No, it's not like that.
No,
I
I'm
just
kidding. I'm
I-
kidding. I'm kidding.
I
You
just
don't have
figured
to answer
because
that.
like everything was kind of figured out before I got here that it would be kind of like a smooth sailing situation. So that's kind of why I didn't know if I needed one or not.
No, it looks like when I look it over, it looks like it's good. You guys have worked it all out. I just can't do anything today on it.
Oh, of course, I understand.
Okay.
Yes.
All right. You take care. Have a great weekend.
You too. Thank you. Bye-bye.
Bye-bye. Peninsula Place versus Michaela Biles.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Tyler Biles? Not present. You may proceed.
Your Honor, I request the default judgment for possession only. Rent to retain is $749.67. Court cost of $177.72 for a total of $927.39. Upon information and belief, Ms. Biles is over the age of 18, not in military service, otherwise within the jurisdiction of this court, and the premises are kept for the use intended.
All right. Judgment to the plaintiff. By default, for possession, redemption amount, any amount requested, writ to issue in 10 days.
Thank you, Your Honor.
Peninsula Place versus, is it Kermasa? Is it Gladzar? Gladzar? They are not checked in. You may proceed.
Your Honor, we had worked out a tentative consent judgment with this defendant, and so perhaps could we just adjourn it a week? I don't want to default her. She had a payment plan.
Got it.
All right.
It looks like it's only 177. That's
Yeah, I don't quite
absolutely appropriate.
either, because that doesn't really match what my so in the next week I'll figure it all out.
Okay. April 10th, 2026 at 2 p.m. Court calls the case at Peninsula Place versus John Chanu.
Good morning, Your Honor. Rebecca Austin for plaintiff.
John Chanu? Not present. You may proceed.
Your Honor, request a default judgment for possession only, rent to retain, $699.67, court costs of $75. Total judgment $774.67. Upon information and belief, Mr. Chanu was over the age of 18, not in active military service, otherwise within the jurisdiction of the court. And this premises were kept in reasonable repair during the term of the lease.
Judgment to the plaintiff. That's by default for possession. Redemption amount, any amount requested with a writ to issue 10 days.
Thank you, Your Honor.
Thank you. Hold it up. Yeah. Court calls the case of Peninsula Place versus Jeremy Jackson.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Hello.
My screen is not working, but Mr. Jackson, say your name again, please.
Jeremy Jackson.
Gotcha. Okay. All right. What is plaintiff's claim in this case?
Payment of rent case, Your Honor. Mr. Jackson currently owes $718.48. It looks like he essentially owes April rent.
That total amount is how much, counsel?
$18.48.
You broke up on me. It's okay. Just give me the number again, please.
71848.
Got it. Okay, that's what I thought. All right, Mr. Jackson, how are you going to get that paid?
I'm actually not sure where that figure came from, as my rent is only $624 per month. But I just paid April's rent this month. I mean, not this month, today, as of this morning before the hearing.
Okay, so probably what you have is you have your rental amount plus court costs.
I paid the court cost. The court cost would have been from March's rent. I paid the entirety of March's rent as well as the court costs. Because the judgment is for March, not April.
No, we're in April. So
No,
April is now included, sir.
I understand that, but they filed before April, is what I'm saying. They filed in March.
I understand that.
So
But
There's
whatever rent comes due, they're entitled to a judgment for. So since we're past April 1st, they're entitled to take a judgment for April rent.
I'm not quite.
Counsel, did you pardon?
I don't quite understand how that works.
Okay. So if they file in the middle of March and you owe March, if you don't get everything paid before we get to April or the court date comes to April, then they're entitled to, let's say you paid nothing. They're entitled to go after March and April.
Okay. But if
Counsel, go ahead. What, sir?
if I paid the balance before April, then does that make a difference or?
Well, it could, but I don't know if that happened in this case.
I rent was paid in full by March 27th.
Do you see that? Do you see that?
I do, Your Honor. It looks like he was down to a zero balance at the end of March, but then because of the court date being in April, they added April rent on and kept him in court.
Well, then you can't do that. Although he was saying it wrong, you can't do that. The judgment could go for that if he owed something as of the end of March, but he didn't. So he's paid through. So effectively, this matter has to be dismissed.
We'll dismiss it then, Your Honor.
Case is dismissed. That's without prejudice. Thank you, sir.
Thank you.
Court does call the case of Peninsula Place versus Donovan Ford.
Rebecca Austin, plaintiff, Your Honor.
Donovan Ford, not present. You may proceed.
Your Honor, to request the default judgment for possession only. Rent to retain is $633.72. Court cost of $75 for a total of $708.72. Upon information and belief, Mr. Ford is over the age of 18, not in military service, not incompetent in this map. These premises were kept fit for the use intended.
Judgment to the plaintiff. That's by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days.
Thank you, Your Honor.
Court calls the case of Peninsula Place versus Camille Cox.
Morning, Your Honor. Austin for plaintiff.
Hi, I'm here.
Okay. Need a camera if you have it. Oh, there you are. Okay. How much is owing?
Your Honor, with court cost $819.67.
All right. Ms. Cox, how are you intending on getting that paid?
So I paid $519 before April 1st. I had paid that. I don't know where 8 come from.
Hold on a second. Did she get down to a zero balance by the end of March?
You did, Your Honor. Would you like me to dismiss this as well?
She did? Okay. Ms. Cox, it's your lucky day. Case is dismissed.
Okay. Thank you.
All right. Okay. Have a good weekend.
Thank you, you too.
Peninsula Place versus, is it Zari Goss?
Rebecca Austin for plaintiff, Your Honor.
Zari Goss, you may proceed.
Your Honor, to request a default judgment for possession only. Rent to retain $1,171.67. Court cost of $177.72 for a balance of $1,349.39. Upon information and belief, Ms. Goss is over the age of 18, not in active military service, not incompetent, and these premises are kept fit for the use intended.
All right. Judgment to the plaintiff by default for possession, redemption amount in the amount requested. Writ issue in 10 days.
Thank you, Your Honor.
Peninsula Place versus Jonathan Weathers.
Good morning, Your Honor. Rebecca Austin.
I'm here.
Jonathan Weathers.
I'm here. You hear me?
Okay. Yep, we can hear you, sir. All right. Plaintiff, what's plaintiff's claim in this case?
This is a non-payment of rent case. Total due is $914.72. And you do also have a proposed consent judgment that I understand will have to get entered next week.
Yes. All right. Sir, you guys have entered into a consent judgment. I can't do anything with it today. So I'm going to have to adjourn
Okay.
this out. I have to adjourn it out to April 10th, 2026 at 2 p.m. That's an in-person hearing, but I would permit, since you guys have already worked it out, for you guys to appear via Zoom, for you to appear via Zoom, so that we can just put that on the record. Okay, sir?
Okay. Well, what time is the Zoom? What time does the Zoom call be? Because I gotta be at working that
It would be
day.
at 2 o'clock.
Okay. I'll
2 o'clock next-
try to make sure I can be in there, and I'll make an arrangement or something like that. So I can make it on there.
Okay, very good. All right, thank you, sir.
Yep. Have a nice day now. Take care.
All right. Peninsula Place versus Andreas Smith Jr.
Morning, Your Honor. Rebecca Austin for plaintiff. Your Honor, we're going to dismiss this case. It's paid in full.
Case is dismissed on plaintiff's motion without prejudice. Peninsula Place versus Janae Martin.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Hi, good morning.
Good morning. You didn't come to my screen, so can you try that again for me?
Oh, yep, sorry. Good morning.
Why? I don't know why it's doing what it's doing. Anyway. All right.
She has that black little hat.
I know where she is. All right. What is plaintiff's claim?
Under the non-payment of rent case, there's currently past due rent of $1,635.22, court costs of $177.72 for a judgment of $1,008.12.94.
All right. So Martin, how are you going to get that paid? Let me put it
Okay,
that way.
I was also gonna request to do a payment plan. I start working next week and I would get paid weekly, but I wouldn't get paid until the week after that, which is technically not for another 2 weeks. So I would need to get in contact with someone about that to try to make weekly payments that way, be
Okay.
able to pay that balance off, if that's okay.
Okay, I got you. Here's what the first thing that I'm going to do is I'm going to adjourn your case 1 week out to April 10th, 2026 at 2 p.m. That's an in-person hearing.
Okay,
What I'm going to suggest that you do is contact the attorney's office or, oh, there she is, Holly. Holly's here.
okay,
So she loves talking to people, that apparently. So contact Holly, go down to the office and see if you guys can work something out. All right, Miss Martin?
okay. Thank you.
All right, we'll see you next week. Take care.
You too.
Peninsula Place versus Jada, is it Shirar?
Yes, Your Honor.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Now they're back on this screen. All right, what is plaintiff's claim?
Rent's a non-payment of rent case. There's currently past due rent of $1,154.67, court cost of $75 for a total of $1,229.67.
All right, ma'am, how are you going to get that paid?
So I paid my March rent on March 18th. When they put a 7-day quit or pay my rent, I am going through a financial hardship right now. My checks are getting garnished and they taking like $400 each of my check. So I originally tried to pay my rent on time. I ended up paying $500 on the first. I ended up paying like $300 on the 13th, and originally everything was due on the 18th. They filed, I got basically like a court of $102 payment, which was paid on March 21st. My March rent is paid in full with the court fee. I only owe April, and my
Hold on,
April.
Miss Shirar, hold on. All right, no, you're trying to tell me a lot. Just take a breath for a minute, okay? All right, here's the deal. Trust me on this. I'm not letting anything happen to you I'm just not letting anything happen. So just take a breath for a minute. I know you're trying to tell me everything, but let me ask this, counsel. Did she have all of her March rent paid by?
She did, Your Honor. We will dismiss this case.
All right. See, Ms. Shirar? I think I knew that's where you were trying to head. So this case is going to be dismissed.
Okay, thank you.
You're welcome. You'll make a good lawyer one day. Yeah. Right. Have a good weekend.
You too.
All right. Peninsula Place versus Jomar Pie.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Hey, how you doing?
Okay. I don't know why this is acting this way. It should come right to my screen. State your name again, sir. Oh, there you are. Never mind. I found you. All right. You guys have worked out a consent judgment, but I can't enter it today. All right, sir?
Yeah,
So you're unrepresented by counsel.
I was in the positive before.
I'm sorry?
I said, I only owe April rent. I was in the positive before this.
He was, Your Honor, also at a zero balance at the end of the month, so we'll dismiss if you'd like.
Okay. So we'll dismiss your case, sir, okay?
I appreciate it.
All right. Take care. Have a good weekend. Peninsula Place versus Danielle Sexton.
Rebecca Austin for plaintiff, Your Honor.
Danielle Sexton.
Hi.
Hello. How are you?
Good. How are you?
I'm doing fantastic. Thanks for asking. Nobody ever cares about the judge. All right. Counsel, how much is owing?
Your Honor, past due rent of $1,277.57, court cost of $177.72 for a total of $1,455.29.
All right. Miss Sexton, how are you intending on getting that?
I paid rent for this month this morning before the call, so that just has to go through. And then I will have
rent
money.
for hold on. You paid rent for what month?
April.
All right. So how much did you pay this morning?
$710.
Okay. All right. So you don't have that counsel on your sheet, right?
I do not, Your Honor, and she did owe for March and April.
Right. Correct. Okay.
I do not have that.
So that actually gets applied, young lady, that actually gets applied to March, but that's okay.
Okay.
I get what you're saying.
Yeah.
Okay. So when do you think you get the balance paid?
I have half of it. I'll have half of it by tonight, and then I should have the other half by Monday.
Okay. So you think you'll be able to get everything paid before the 10th, certainly, right?
Yeah.
Okay. So here's what I'll do. I'll just indicate in the file that you're going to have the balance paid. I'll just pick a date next week by the 8th, let's say.
Okay.
Okay. I'll adjourn your case out to the 10th, 2026 at 2 p.m. That's an in-person hearing, but if you've got everything paid and you're sure you got everything paid, I don't need to see you.
Okay. Thank you so much.
All right. Thank you. Have a good weekend.
You too.
Peninsula Place versus Isis Cunningham.
Rebecca Austin for plaintiff, Your Honor.
Hello.
Isis. Hello, Ms. Cunningham. I'll need a camera. Oh, there you are. Okay.
Yep.
Okay. How much is owing?
Past due rent $1,340.88. Court cost of $177.72 for a total of $1,518.60.
Okay, Ms. Cunningham, how are you intending on getting that paid?
Could I get the total cost of it again? Sorry.
The total is $1,518.60.
Okay. Thank you. I will have what I owed for March paid up to date by today at the end of the day, and then I'll have April's rent taken care of by the 9th of April. I'm just curious on if another court fee was added to my account, because when I received my paperwork, I originally owed like $6 something, and then with the court costs and late fees, it was $809, and my rent is $641. So I did the math from how much I currently owe, and I was just curious on why it's $118.
Well, the statutory attorney fees added in, Your Honor, that extra $75.
Okay, so
Okay.
there's a 75 that got added. That
Okay.
wasn't there before. Okay.
But yeah, everything will be taken care of before the next court hearing.
Okay, so all right. So you're gonna have everything paid by the 9th.
Yes.
All right. So what I'm gonna do is I'm gonna indicate in file that you have the balance by the 9th. I will adjourn this out to April 10th, 2026, 2 p.m. That's an in-person hearing. But if you have everything paid, I don't need to see you. But if everything's
Yes.
not paid,
Yes.
you'll need to come down.
Yes. I know.
You know? Okay. All right.
I don't know if you remember me, but I came last at the end, and you were like, it was amazing how I had got so much paid down within a short time. Because I do take care of my stuff. It's just I need a little time.
Okay. I don't necessarily remember, but you know that you're good. Okay.
Okay.
All right,
Thank
then.
you.
You have a great weekend.
You as well.
All right. Peninsula Place versus Carly Kennedy. That matter's dismissed on plaintiff's motion without prejudice. And I think that's it for you, counsel.
That's it, Your
And
Honor.
Holly. I think that's it. You guys have a great, great, great weekend.
You too. Thank you.
All right. Court does call the case South Washington Properties versus Matthew Taylor.
Morning, Your Honor. Stephen Jensen appearing on behalf of the plaintiff.
They didn't want you to be. I was looking out for you. Need you to know that. Court does recall the case of the people of the state of Michigan versus Ronald Fleming.
Ashley Lonnie Feltus for the people.
Good afternoon, may it please the court, Kareem Johnson on behalf of Mr. Fleming.
The court has heard the testimony and argument of counsel regarding the preliminary examination in this case. The issue, and it have to be dealt with, certainly at circuit court for the purposes of the search. However, court in looking at case law and also just the factual circumstances, they're a little bit different than anything the court was able to find. But what is very clear is that when the first deputy arrived, that there was given to that deputy consent to search the premises. There's not a doubt in this court's mind that there was. And that whether or not that person granting that consent, either one of the two that originally are, I think it was reasonable that the officer were to believe that they had apparent authority to grant permission for the search of the premises. The question then becomes, and I think it's also important, and Mr. Johnson has brought up on behalf of the defendant, the issue of standing to challenge the search. And then their standing is different from that apparent authority or grant of consent. Standing would come into play if there were a challenge to the search. And does somebody have standing to raise that challenge? That really is the customary way that that would work. And I don't think that this really would involve an issue of standing, but certainly as to whether or not there was proper consent and whether or not the officer acted certainly in good faith in terms of that consent. I think it's also important to point out, as the court has, that consent, at no point do I see that the officers acted beyond the scope of the consent that was granted. Just on the face of it, they went into the house, but then came out of the house and at some point re-entered the house, but they were searching the house and the adjoining area. There was a walk around in terms of the backyard because the freshly dug portion of the garden area where the decedent was found was indeed noticed by the officer at a certain point. He doesn't do anything with that at that point, but is still going around. And if the court, in terms of the court's notes, it is correct, there's other information being given to the officers that are there. For example, that we can't find a decedent. We've done all the calling around to hospitals, ambulance, seeing if there are calls for service. There aren't any. But then at some point, they're given her house keys, car keys. Her phone is obviously there. There are, her vehicle is there, and she's not anywhere that they can see. And certainly at that point, one can look at it in a lot of ways. Either I think under a certain theory, they're operating on that consent, but I think also those items are creating certain extended circumstances for these officers to continue doing what they're doing, because we cannot locate this individual. But what appear to be all of their personal effects are there. They're at the house. So something certainly is amiss, and it involves an elderly human being, and they go through that process. So from this court's perspective, I don't think there's an issue, certainly regarding the consent to search and the initial search that was done. Had Detective Rob or Deputy Rob at that point, upon discovering what he discovered, continued doing something, then maybe we get into another issue of whether or not there should have been a warrant for him to continue on. But I don't think his intrusion and the, say, minor digging, but is looking to uncover what this was in front of him, in search for this individual that they can't find, is beyond what would have been the consent that was granted. Would also know the three people there, those that court believes certainly had apparent authority to grant, from the officer's perspective, to grant consent, as well as the person that defendant claims had the actual ability, then, which I don't entirely agree with, but understand the point. While his deputies doing all of this, no one is objecting at all, which I think is further indicia of the consent that was granted to the officer to act. And so for those reasons, I don't find that the issue of the consent, it was followed up with the warrant, with reference to the charges of the open murder outside of the confession of the defendant as to what they did and how they killed the decedent in this case. There is also ample evidence where he's in this sort of curtained out dark house in the basement where the owner of that premises hasn't been seen for 3 or 4 days. He does nothing, does not act, does, at least apparently based upon this record, does nothing. To this court indicates not only that he intended to kill the defendant or kill the decedent and did so, but also intended in some way, based upon his actions of taking the body, burying it. In doing that, he was covering up his criminal activity. So taking all of that to account, and just one other thing, I do not find that there's anything defective in the Miranda warnings given, and who it was, the Detective Morrison testified that she believed that upon giving of those warnings, that the defendant understood those warnings, and that the assessment that she made is that he voluntarily waived those rights, and that he did answer. So taking all of that into consideration, taking all of the evidence, including People's Exhibit 1 into evidence, the court does believe that the people have indeed sustained their burden in this case and would find the defendant over on the charge of overload. Johnson, you acknowledge receipt of the information waiver treaty.
Yes, Your Honor, I do.
All right. Your client is standing mute to the charges.
Yes, sir.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set
May 26th at 1:30 with Judge Conkey.
May 26, 2026, 1:30 before Judge Conkey.
Thank you. May I present him?
Thank you. Yes, bond, denial of bond will continue. Just need the top back. All righty. That it for us? 14A stands adjourned.
Picked her up and that he drugged her out there after he had killed her.
Did he describe killing her?
Yes.
What did he say about that?
You said that on Tuesday morning, his grandmother had come downstairs. I guess I should back up and say that earlier, Monday, they had gotten into a little bit of an argument about what happened at the vet. She also had been talking to him about getting a job or going back to school. This made him feel like his grandmother didn't love him anymore. He had felt that way for a while.
You said the vet. Let's stop there for a second and back you. You said something about Monday at the vet. What happened Monday? What did the defendant say happened Monday at the vet?
Monday at the vet, he said that Phaedra got upset with him because he was laughing. The dog, this big dog, he's uncontrollable.
And they had gone to the vet with the dog?
Yeah.
What happened while they were at the vet?
So the defendant had a whole Humphrey, who's the dog, had a whole Humphrey, and because he wasn't sedated properly. And so Phaedra got upset, and Ronald ended up storming out by leaving Phaedra there.
What did he say happened later on Monday?
They had a conversation about him getting a job and going back to school.
And anything else that happened that he said between the two of them? What about Tuesday? Anything that he said happened between the two of them on Tuesday?
Tuesday, Phaedra came downstairs, asked him about getting a job or going back to school again. He said that Phaedra had a knife in her hand, and that he came out of his bedroom. She was standing in the threshold to the door, kind of just with her hands. The way that he did it in the interview was just kind of like her hands on her hips, as a grandmother would.
You just made a motion with your arms that I want to describe and make sure is accurate. You've sort of closed your hands and placed the tops of your hands on your hips with your elbows out at an angle. Is that correct? Does that describe the way that he said Theodore was holding her arms?
That's how he displayed it in the interview.
Very good. What did he say happened after that?
He said that he came out and that they continued their quote unquote.
What happened next?
He says that Phaedra lunged at him. He grabbed her, spun her around, disarmed her.
When you say disarmed her, what do you mean?
So he did a reenactment with Detective Bryson, and he said that he knocked the knife out of her hand.
What did he say he did after he knocked the knife out of her hand?
He put her in what I would call a very naked choke. So he demonstrated putting his arm around Phaedra's neck, and that she was able to escape from that. And she turned towards him and tried to claw at his face. So he grabbed Phaedra around the throat, both of his hands, and strangled her until he got her neck.
Did you ask him if he had been hurt during this at all?
Yeah.
What did he say?
He said, that he had some scratches on his arm, on his left arm. He also gave alternative, explanation for it, that either being the dog had scratched him on Monday. He at one point said maybe the knife, that he recanted that, that was the knife that, either the dog or teacher had scratched on their names.
You described a few moments ago that he had put her in what you called a rear naked chokehold. Could you describe exactly the positioning of their two bodies that he said that they had while he strangled her with his arm?
So a rear naked choke for me, would be his arm was below her neck, coming around, cutting off the airway, or the neck. Her back would be against his chest, so she would be facing away from him and he would be directly behind.
What did he say happened after Theodora? Well, he said he strangled her until he felt her neck snap. What happened? What did he say happened after that?
He drove her body to the back of the basement, where there was like maybe like a storage or wine cellar area, which kind of like a big area with shelves. He laid her against the wall. And then later he put her on top of a quilt in that area. He waited till it got dark, and then he carried her up the stairs. His explanation for that was that she was heavy. He went outside, and in the area where the garden had been previously dug up for some hostas, other plants. He just left her laying there on the ground and then dug the hole so that it was big enough for a teacher to fit in. And then
May I have a moment, Your Honor? I'll pass the witness.
Cross-examination.
Good afternoon, ma'am.
Yeah.
How long you been a detective?
21.
So you've been trained on taking statements from suspects in custody? One of those things you've been trained on is when a suspect's in custody, before they can be interrogated, they must give a waiver of their Miranda rights. And that waiver, you've been trained, has to be voluntary.
Yeah.
And the individual has to understand the rights that they are waiving.
Yes.
Is your testimony before this court today that when you saw Mr. Fleming Jr., the defendant, were you able to observe him?
Yeah.
You were able to observe his mannerisms?
Yeah.
You were able to observe his speech? Yeah. And you believe that he was of competent mind to waive his Miranda warnings?
Object to that.
Sustained. Sustained. As to the phrasing of the question. Go ahead.
Did you believe that he understood his Miranda warnings? You didn't see anything to alert you that he may have some sort of a mental illness or mental situation prohibiting him understanding those Miranda warnings?
Fleming stated that he had some college education, that he had not been drinking, and that he had stopped smoking marijuana so that he could gain employment.
And at this time, I'd ask the court to take judicial notice that Mr. Fleming Jr. had been found incompetent. It was at the forensic center, I believe, according to the court file, for close to a year.
Yeah, he said to restore the competency.
That he's since been restored.
He's since been restored, absolutely.
But you're asking me to take judicial notice of the competency time frame?
Yes, Your Honor. One of the things,
but you're not asking me, because I couldn't, to make a finding regardless of that as to his competency on the date and time that he's questioned.
No, but you couldn't do that, but we'll be asking you to take that into consideration in evaluating the statement. The court can, when evaluating the statement of defendant, consider circumstances surrounding this. One of those circumstances would be his mental state.
Yes, but you're asking me to, I think, take his competency as a way of indicating that I would be basically adjudicating his competency on the date and time that he's questioned, based upon what was a finding that happened later.
Yes, Your Honor.
I don't think I could do that.
If that's court's ruling, we accept that.
Okay.
Yep. No further questions, John.
Any redirect?
I have a redirect, Your Honor.
Okay, you may step down. Thank you. Additional witnesses.
No additional witnesses, Your Honor, request.
No witnesses, John.
All right.
Your Honor, people do request the court bind over the defendant on the sole count of open murder for the death of Theodore Fleming. I do believe that we have established by a probable cause standard that the defendant did cause her death. And I ask the court bind this matter over for further proceedings. I'll reserve any further argument for rebuttal.
Right.
Yeah, we'd ask the court to not bind over and really rely on two reasons. We believe here the warrantless entry into the home of Mr. Fleming Jr. can only be justified under the emergency aid exception. Now, the emergency aid exception allows police to make a warrantless entry into a dwelling in which they reasonably believe, based on specific articulable facts, that some person within that dwelling is in the immediate need of aid. They are not allowed to do anything more than that is necessary to render aid to a person who may need aid. Here, the responding officer, based on the testimony here, we would concede that the initial entry into the home was under an emergency aid exception. He received information from family members saying that they hadn't heard from a family member for quite some time, that was unusual for that family member, which is important. The court has to determine whether or not it was unusual for this family member to not be in contact with other family members for days in order for the court to render this emergency aid exception valid. And then the officer goes in and does a check to see if there's anybody in the home that needs aid. There is not. At that point, the officer has done everything that is necessary to determine if there's somebody in that home that needs emergency aid. Now, this is a criminal investigation. He is suspicious about the whereabouts of the individual who's missing, Thedra, and he is investigating that. As part of that investigation, he goes to a backyard. He starts digging. He does not have consent of anybody that has standing or authority to grant consent to dig in that backyard. He digs in that backyard without a warrant. He makes a discovery of the body. That information is passed along to a detective who ultimately gets a warrant, but based on the questioning of that deputy, the substantial majority of the information that came from or that went into the affidavit came from the people who were at the scene and would have come from the unlawful digging and warrantless digging into the backyard. So any argument that inevitable discovery would apply to the discovery of the body, I don't think can stand. Your Honor, we'd ask the court to suppress the discovery of the body in this case because the officer clearly acted outside the exigent circumstances exception when he started digging in the backyard. There is no reasonable argument anybody can make that the officer thought that somebody needed emergency assistance when he started digging into that backyard. And the courts have been clear, there is no homicide exception that applies to the exigent circumstances or warrantless search exception. Secondly, Your Honor, we'd ask the court to not give any credibility to the statement given by Mr. Fleming Jr. To the detective. I think the court can, looking at the circumstances surrounding the giving of that statement, that my client was not in a position in which to credibly make a decision to speak to police and waive his Miranda rights, Your Honor. Thank you.
Thank you, Your Honor. I will start by acknowledging that I think defense counsel's asked for suppression of evidence based on the lack of a warrant for the initial discovery of Theodra's body. The question before the court, I know the court knows, is of course bind over on the homicide. So I don't know that I understand defense counsel's request and his argument, but I do believe that the suppression issue will be fully litigated in circuit court.
Yeah, but that doesn't mean that the defense can't raise it at some point, because if I were to agree with the defendant, then there may not be probable cause to bind the defendant over.
Yes, Your Honor.
Yes, sir.
And we appreciate it coming up, and I anticipated this issue coming up at this level as well as when we get into circuit court. I will say that there is more than one exception that applies and that people would allege apply. First of all, consent. The first initial search of the home when we talk about our consent exception is done with somebody that appears to have authority. Your sister has a key to your house and she hasn't heard from you. She can give consent to a police officer to go in as a community caretaker, as agent of yourself, to look for this person. So I do believe that the search with the initial house would be fine for consent, as well as the secondary search. When the defendant, Ms. Tony Curry, and Mr. Reynolds Sr. are all asked if he can look again, and the defendant, in fact, locks the dog up in the run and goes ahead and looks. Also, Your Honor, I think that it is important to consider the exigency of the situation. This is an elderly woman. No one's heard from her in days. Her phone is full of missed calls, full of unanswered text messages, emails, all these sorts of things that the detective Rob did indicate to the court. So I think it's important for the court to consider that there is an exigency element here. We don't know where Theodora is. We're looking for Theodora. At the time that he's speaking with Detective Rob, at that time, the defendant is the only person in the home. He hasn't seen Theodora. He doesn't know anything. He doesn't know where she is. He hasn't heard from her. And it's concerning. We are not sure where Theodora is. I do believe that we have sustained our burden. I think that we do have at least more than one exception to the warrant requirement that would apply here. And inevitable discovery is one of them. Theodora would have continued to be missing. There would have continued likely to be more investigation, more police contact, more police involvement in this case. So I do ask that the court bind this case over and allow us to proceed to trial in the circuit court.
Yes, sir. If the prosecution was to argue community caretaking actually has a higher burden than exigent circumstance. Exigent circumstance is reasonable belief. Community caretaking is probable cause. And for community caretaking, they have to show that these officers believe that there was an ongoing emergency and a danger to the public. There is clearly no testimony that they believe to that. And the deputy testified he did not ask for consent before he started digging. So there could be no consent to that portion. We conceded in our
would consent to access to the premises have to be to every act?
Yes, the officer has to operate.
What I'm asking is, if you give me consent to go into the house, I don't have to get separate consent to enter the kitchen as opposed to entering the bedroom. Right?
That is correct, Your Honor. And now consent, now he's now dead, not on the court anymore. Now I didn't agree with a lot that Justice Andrew Scalia said, but he was not a fan of consent.
Yeah.
I actually am.
That Mr. Johnson is going to quote Scalia. Go ahead, sir.
And the aspect that he was not a fan of consent because he didn't really believe that suspects could ever really consent to armed police officers. But he and the courts have always kept consent and made it very narrow and tight, that an officer has to have consent for the specific actions that they are engaging in. I agree with you. If an officer asks me to search my home, that includes the bedroom and the kitchen, because I can revoke the consent at any time. But if an officer asks me to search my home, and then the officer then goes into the backyard and starts digging up, engaging in action that he has not asked for permission to do, then that will be outside the scope of consent.
Yeah, but hold on. That's not what happened here, though, because the officer never leaves. The officer it's not as though the officer was in the house, got consent to do something in the house, then walked outside and just went to the backyard. They had already been through the backyard, had gone through. So this was, where are you saying, if this court believes that there was consent not only to search the house, but also to search the premises, where are you saying that consent ended?
It is
where they needed additional.
Yes. I concede there was consent to search the house. There was never any testimony of consent to search the yard or the structure that was in the yard. It is our position that the deputy needed additional consent.
Why would he have needed additional consent? Because when they're in the home, they all leave the premises and start walking around the outside of the premises into the yard. Right. So you're saying that once he's in, then they come out, that he has to have some separate consent?
To dig in the backyard.
Well, no, because once he's there, the digging would be like searching the house and moving a board, and all of a sudden you see something. The issue of consent, I'm trying to figure out where you're saying he needed additional consent.
He needed additional consent to search the yard. He had permission to search the home. He did not have permission to search the yard. And it's our position that the deputy knew it. That's why he didn't ask. He just went back there and started digging. He didn't even ask for permission to search the yard. And we believe.
But if the deputy believed he already had consent, of course, he wouldn't ask again necessarily, right?
Well, he didn't testify that he believed that he already had consent. So, I mean, that I guess that's something the court will have.
Well, the actions of what happening are a continuation. If one believes that consent was originally given, that he's walking around with the individuals that are giving him that consent. I mean, he's given a key, go into the premises. The three of them are there. The three other individuals
are in the house, yes.
In the house, but ultimately they're all outside, right? And then there is this searching around the premise.
Right, they're not all outside at the time of digging. They're, based on the testimony, and it is our position, the only person that had authority to grant consent was Mr. Fleming Jr. We do not believe that there's facts in the record that would establish by probable cause that this officer could have believed that anybody else had the apparent authority to grant him consent after the moment he discovered that Mr. Fleming.
Wouldn't I believe that a person who hands me the key to the premises has the apparent authority to give me consent to search? Why wouldn't I believe that? Why wouldn't that be a reasonable belief?
Your Honor, people give keys to neighbors or family members for, all kind of emergency reasons. That doesn't mean that they can.
But that, as to whether or not that person, there's a difference between whether or not that person exceeded their authority and whether or not the person who is sort of believes they have consent reasonably believes under the circumstances that this person can grant consent for me to search.
And Your Honor, I think we are, we getting off. We're in separate lanes. We've conceded.
Oh no, I know we're in separate lanes.
We've conceded the initial entry into the house was based upon the apparent authority of a woman that was there. Okay. Once the deputy discovered that the only person that lived there was Ronald Fleming, then the apparent authority of anybody else there has now been dissipated. There's only one person who would have standing to grant a search under those circumstances. Now, we can get into
I'd like to Olson case law on that because I don't think that's true.
Minnesota v. Olson
comes in, the deputy comes into the home. He's searching. I find somebody there. Somebody says they live there. You're saying at that point, the consent terminates?
Yeah, what I'm saying is the apparent authority terminates. Remember the testimony. The officer didn't ask these individuals any questions to ascertain whether or not they had any legal standing in that location. The only person, based on the testimony, that had legal standing in that location was Ronald Fleming Jr. Surely under Minnesota v. Olson, I don't think there's any argument the government could make and that the court could accept that Ronald Fleming Sr. or this other woman had standing at that location. So now we're looking at who had the apparent authority to grant the second consent search.
But why was the second one needed?
Because the search had terminated, the first search had terminated.
And
yes.
They hadn't left the premise. I mean, where are you saying it terminated?
When the deputy does not find Deidre, comes back out with Mr. Fleming Jr., and he's given that testimony about him being outside for some period of time, talking with the family, before he asks again if he can go search. It is our position that second entry was not an exigent circumstances search. It wasn't even a community caretaking search. It was simply a consent search. She was not there. There was no reason for him to believe that she was inside that home and needed aid. But he had consent to search the home, which at that point was given. We are not contesting that. The issue here is the scope of that search. The scope of that search did not exceed to the backyard.
But the problem is that problem with that analysis is the individuals, it's the officers acting, the individuals who have granted him the consent as they're going around are the same individuals that are going around the backyard with him. That's the problem or the trouble I guess I'm having with your argument. It's not as though he had never gone into the backyard prior to that. That's not what happened here. That initial search, you'd have to show me something that initial search, that consent that the officer was acting under only included the physical structure of the house and didn't include the outside, because the factual circumstance of this clearly in my mind indicate there was also this consent to search the entirety of that premise.
Now, with that concept, it is our position that the courts of higher jurisdiction have taken a separate position that the court has taken. It is the position of the government to show that the consent was valid, what the scope of the consent was, and that the officers acted within that scope. It is not my burden to establish in a warrantless search that the government acted outside the scope.
No, but I understand that part of the argument, but you're saying that at some point it ended or didn't include the outside of the premises.
Exactly.
And I'm asking you, when did that happen? I'm stating what the facts are as I see them, and that is that there was the inside, there's the outside, they're all going around the premises. At no point did that search stop.
Well, I guess that makes it easier for me. So under the case law, the court has to ask itself three questions. Did the officer ask anybody with standing to grant permission to search that backyard? The answer to that question is no. Did the officer have a search warrant to search that backyard? The answer to that question is no. And so now is that the consent is ambiguous, or there's an ambiguity in the consent of who has the burden of showing that the officer's actions were within the scope of that consent, and that is the government. And here,
you're saying that when they first come to the house, someone hands him a key, the officer goes in, that even apparent authority to the apparent authority that person exhibits granting consent at some point just disappears?
Absolutely. My sister has a key to my house. She hasn't heard from me.
Both can be true, Mr. Johnson. One can have apparent authority grant that consent, but also there be another person that can grant consent. It doesn't make the other, it doesn't negate the other. Both can be true at the same time. Can't they?
I don't think so, Your Honor. My sister has a key to my house. She calls the police and says, I haven't heard from whomever that lives at this residence. I'm giving you permission to enter. The police enter the location. They see me there. I live there. At this point, no reasonable officer could think that my sister, who doesn't live there, has the apparent authority to continue to grant searches at that location when an individual who lives at that location is actually present.
Okay. But isn't that dependent upon what one's searching for?
No, Your Honor, the emergency aid exceptions made that clear. The heightened or crime that is suspected or the type of emergency that is suspected has no bearing, because the courts of higher jurisdiction have always been clear. Go get a search warrant. There is no reason why this officer could not have radioed in and said, hey, been caught out here for a welfare check, not find anybody. These are my, levels of suspicion. Need a search warrant to search the entire premises.
In this brief courtroom moment, the judge explains that although the parties seem to have already worked out an agreement, the court cannot officially enter the judgment yet because one side does not have an attorney present. The judge clarifies that the person may hire an attorney if they want, but it is not required. The case will instead move forward on the next scheduled date, where the issue can be finalized properly. The exchange highlights how courts must follow legal procedure even when both sides believe the matter has already been resolved. Question: do you think it's better to hire an attorney even when the court says it's optional? If you enjoy real courtroom moments like this, like the video and subscribe for more courtroom content.